Hi, hello, welcome everyone, and thank you for joining this webinar on international data transfers after Schrems II. Today, we will discuss the recently published EDPB Recommendations and the draft Standard Contractual Clauses. My name is Tim Vankanet. I'm partner in Fieldfish's Brussels privacy team, and I'm joined by three of my privacy partners across Europe. Olivier Proust is a French qualified privacy expert based in Brussels. Thorsten Ihler is based in our German office in Hamburg, and last but not least, we have Philly from our London office. So to start with a few housekeeping notes, first of all, please note that this session will be recorded or is being recorded. And the good thing is obviously that this means that in the days after the webinar, we will not only send you a copy of the slides, but also a link to the recording. So no need to scribble notes like a maniac. Questions, obviously, we'll be happy to take your questions. You can submit them in the question box. We will try to answer as many as we can. Obviously, we only have 1 hour and we have a lot of participants and we're very grateful for that. So we'll take as many questions as we can. And then finally, throughout the panel session, we will launch a few polls. And we obviously look forward to receiving your answers to these. We're quite interested to hear your views. All right, so before we start the panel discussion, for which we have foreseen the larger part of this webinar, let me quickly recap the situation. And it obviously all started with the Court of Justice Schrems II decision over the summer. And in a nutshell, the Court of Justice decided two things. First, it invalidated the EU-US Privacy Shield adequacy decision, which is important, but we won't dwell on that for today's webinar. We will focus today on the second aspect, the fact that the court concluded that yes, standard contractual clauses are still a valid transfer mechanism, but, and a big but, even when relying on appropriate safeguards like standard contractual clauses, or BCR for that matter, you must verify whether an essentially equivalent level of protection is guaranteed. Now, if that is not the case, the Court of Justice basically indicated that data exporters should implement so-called supplementary measures in view of ensuring an adequate level of protection. If those supplementary measures do not allow you to achieve that essentially equivalent level of protection, well, then the transfer is plainly prohibited. And that obviously then brings me to the recommendations that the EDPB has just published. And I should add that these are not just recommendations, these are currently still draft recommendations, which are subject to a public consultation until the 21st of December. Obviously, what we've seen in the past is that there may be tweaks to these recommendations, but typically we don't see major or very substantial changes to this document. So we already know quite well what we may expect. So two sets of recommendations which aim at clarifying first what supplementary measures can be adopted and as well which steps you should be taken when you export data. And we have a second set which contains the so-called essential guarantees for European essential guarantees, which should be found in the laws of the third country of which you are assessing the adequacy. The EDPB has prepared a roadmap of the steps that organizations should follow when they want to transfer data. I won't go in much detail into that roadmap because we will be discussing this in our panel discussion, but quickly walking you through the different steps. I think if you look at the first two steps, those are quite self-evident. First, data exporters must know their data transfers, of course, and also the transfer tools that they rely on in that context. I think that is pretty straightforward, but then it starts to get interesting or complicated as you want, where a transfer is based on appropriate safeguards like standard contractual clauses. you are required as a data exporter to conduct a so-called transfer impact assessment. An assessment to verify whether the third country to which you will send the data offers an adequate level of protection. If that is not the case, well, then you have to assess whether the adoption of supplementary measures, and these can be technical, contractual, or organizational, whether those supplementary measures may allow you to ensure an essentially equivalent level of protection. If that is not the case, well, again, as I mentioned before, the transfer is prohibited according to these EDPB recommendations. If it is possible to reach this level of protection, well, then the transfer may go ahead, but even then, that's not all. You will still have to assess whether or not you need to take procedural steps. Think about supplementary measures that contradict your standard contractual clauses. Well, this may trigger the need to seek approval from your supervisory authority. So you will need to assess that. And then finally, and this should not come as a surprise, bearing in mind your accountability obligation, you will have to reevaluate the situation on a regular basis in both scenarios. Okay, so as I said, we will discuss shortly what this all means in practice, but before starting that discussion, let me say a few words about the future standard contractual clauses. And here as well, I should emphasize the fact that these are the draft standard contractual clauses. So the European Commission only published a draft, again, with a public consultation that will end on the 10th of December. Sorry. Okay, so what are the differences? Well, if we compare the draft to the current sets of contractual clauses, well, today we have 3 sets that cover 2 scenarios, the controller-to-controller transfers and the controller-to-processor transfers. Well, in the future, there will only be 1 set of standard contractual clauses, but, and that's a good thing, it will cover 4 scenarios. Obviously, the 2 that I mentioned, which we know and have today, but we will also finally get the long-awaited, should I say, processor-to-subprocessor contractual clauses, and there is even a possibility to implement processor-to-controller standard contractual clauses. Now, with regard to those draft standard contractual clauses, as you can imagine, that's always the case. They are improving certain things compared to the current situation, but they also present a number of challenges. For the purpose of today's webinar, I won't, well, I can't dwell too much on these because of time limitations. If you want a more in-depth analysis, I think Phil's article called The Good, the Bad, and the Ugly not only has a great title, but gives you an excellent recap of the draft standard contractual clauses, and you can find that on our Privacy, Security, and Information Law blog. Just a few things that I want to point out here for the purpose of this webinar today. On the upsides, some of the improvements, well, the fact that you can use the standard contractual clauses now in scenarios where the exporter is based outside of the EEA. That's a huge improvement, of course, because currently that is not possible under the current clauses. Secondly, the new clauses recognize that for auditing purposes, a data exporter may rely on an independent audit that has been mandated by his data importer. Again, something which was not expressly foreseen, and there was a lot of unclarity about this today. But also the fact that the standard contractual clauses recognize that in certain situations, as a data importer, you may not be authorized by the laws of your country to notify the importer of, or the data subject, depending, of government access requests. So the fact that this is sort of recognized in the standard contractual clauses is also helpful. Very quickly on the more challenging provisions, in my view, or in our view, the standard contractual clauses require quite unrealistically, we think that the subprocessor interacts directly with the ultimate controller. So take a situation where you have a subprocessor as simply hosting data for an other service provider. Well, in case of a data breach, for instance, there might be a required interaction with the end customers, the ultimate controllers. We don't think that is always very realistic. Similarly, obligations that are imposed on data importers when it comes to government access requests are very onerous. It's not a surprise as such, given the Schrems II decision, but still it is very challenging. If you see that the Standard Contractual Clauses contain a provision, an obligation for importers to exhaust, and I'm quoting here, all available remedies to challenge the requests, if there are grounds under the laws of the country of destination to do so. That is going much further than many data importers would typically want to go. So I think with that said, that it's fair to say that yes, those recommendations and the future SECs have the merit of clarifying certain things, but they are certainly and unfortunately not a magic wand that will resolve all the practical challenges. And with that said, Olivier, Phil, Thorsten, I'm quite keen to hear your views on all these developments. For the benefit of the attendees, I would like to structure our discussion around 4 topics. I have only one question about the first 2 steps of the roadmap that the EDPB is proposing. As you probably can imagine, I have quite a few questions around adequacy assessment and the supplementary measures. And at the end, I would like to address a few practical questions. One, should you take action? What about transfers to the US? Brexit, anyone? And also BCR. So with that said, let's jump into the discussion. And my first question is a question to you, Olivier, which deals with the first 2 steps of the roadmap that the EDPB is proposing. I was wondering if you could briefly explain what organizations should be doing, practically speaking, to comply with the expectations of the EDPB.
Yes, well, thank you, Tim, and I hope everyone can hear me well. If it's not the case, just shake your head. So indeed, the EDPB guidelines highlight and stress the importance of doing an assessment of your data transfers, data flows. In that, I think it's not really anything new or completely groundbreaking, because I think the EDPB is really relying here on the accountability principle that is the backbone of the GDPR. And we know that in other areas, such as data protection impact assessments, the idea that you have to analyze and assess your data is something that we are already familiar with. So what the EDPB is really doing here is highlighting and going into a little bit more detail and focusing more on data transfers and data flows. Now, practically speaking, what should companies do? Well, I think there are a number of things that companies should be doing, and obviously this will vary and will be different depending on the size of the company or the sector that it is in. But more on the technical side, I think it's quite obvious now that companies should have a good understanding of what data they are processing, where they are sending the data to whom they are sending it, and in which countries. So this is probably going to require companies to rely on certain service providers or technical tools to carry out this assessment and to really do a full-blown data mapping exercise. So that is maybe on the more technical side. On the more legal side, I think here again, there's nothing really groundbreaking, given that we are all familiar with the Article 30, the fact that companies have to maintain records of their data processing activities. And so this, this analysis and assessment, and especially this exercise of documenting what you have, is something that companies should already be doing. And as part of this documenting exercise, it is, they should already be integrating in their Article 30 records the fact that they are transferring personal data outside of the EEA. Other things that I think are probably going to become more of a habit is also relying on your processors to provide information to the data controller about onward transfers to sub-processors. And so as part of the contractual discussions and negotiations, asking the providers, throughout the chain and the supply chain to bring up the information to the data controller so that the controller has the full picture of the data flows is also something that is probably going to become more frequent in the months to come.
Okay, thank you, Olivier. So I conclude and I understand that as such, these two steps are not groundbreaking, and many organizations will have a lot, if not all, the required information available in their Article 30 records. But at the minimum, everyone should be verifying whether their data is available and whether it's still up to date. So that was a first question, and I think probably the easiest question. It's not a very contentious topic. So let's move on to something, well, to where the fun begins. The adequacy assessment, the transfer impact assessments. Phil, in your view, how realistic is it that data exporters assess the adequacy of a third country if we have seen with the EC and all the resources that the European Commission has, that they missed the ball twice, once with privacy, with safe harbor, and then afterwards with the privacy shield. I mean, we're talking about something which is complex, and obviously not every organization is a very large one and has a lot of people, resources, or money to conduct it. So what is your view on this?
I mean, I think that's exactly right, Tim. It's an enormously challenging issue for many organizations, even those that are of some scale. I mean, just very briefly commenting on the previous question, I'm regularly told by my doctor I should eat 5 veg a day. Unfortunately, it doesn't mean that I always do. And I think that's true for Article 30 records as well. We know that companies should have them, they don't always do. I think that's a challenging issue for organizations, but when you compound that with the issue of then having to assess the adequacy of other countries, it becomes even more challenging. I mean, I was looking up just before today's webinar that the quickest adequacy assessment the EU has ever conducted took 18 months. And I think when you view that in the context of most commercial data transfers and cloud processing and agile development and all those kinds of things, typically where companies are looking to make new transfers on a weekly or a monthly basis, those times of assessment timescales simply don't work within the context of the way that organizations operate. And if you take that into account with the fact that it's not simply a question of the time of the assessment, but it's actually having the knowledge and the resource to do that. Because a lot of organizations may not have dedicated privacy staff, or those that do will have perhaps 1 or 2 people who do it. And suddenly we're expecting those people to become experts in global data protection law. I can talk reasonably sensibly to European law and to a degree a little bit to US law, but I certainly don't know much beyond that. And I have to rely very much on external counsel to provide me with that kind of guidance. I think what we're going to see here is that a lot of companies are going to be a bit at sea with this requirement. And probably what I would anticipate would happen is that where they are transferring data to third-party vendors, they're going to be passing that question down to their vendors and saying to them, presumably you've conducted an assessment of where you store our data, so please can you share your assessments with us? And customers will become very dependent on their vendors to provide that information back to them so they can form a view as to whether or not they're comfortable using that vendor.
I think that's an interesting point, Phil. The role that vendors, the data importers may play in this. You're suggesting, well, you are saying that data exporters may reach out to them to get that information. And to what extent do you think that the data importers should also take an active role in this? it may help them towards their clients, but doesn't it present some level of risk for them as well to do the adequacy or to provide the input for the adequacy assessment?
I think a lot of vendors will be faced with a mixture of both commercial and legal risk with this one. The legal risk they will worry about is that any kind of concerns that they are giving legal advice to their customers when they're not qualified to do so, or perhaps that they are, kind of providing some kind of representation or warranty about the safety of a third country where they are, storing and processing data. And so there will be a degree of anxiety about that, particularly if it subsequently turns out that a regulator disagrees with their assessment, and the degree to which either a regulator or a customer may then pursue them for misrepresenting the safety of that third country. But I think against that, a lot of vendors are going to increasingly face these questions from their customers, and they will be in a competitive situation where customers will be looking between maybe a small number of vendors who can provide them with some reassurance about the safety of the data that they are receiving. And so those vendors, they have to balance that legal risk they face with the commercial risk, which is probably the more pressing risk for them, that if they don't have a good answer to these questions, their customers will go elsewhere.
Yeah, no, yeah, I think that is a good point, and obviously, yeah, a balance that will not be easy to strike for the vendors. Thorsten, we heard Phil say that it is a quite daunting task, basically, to conduct one adequacy assessment. Obviously, we know that data exporters typically transfer data to many third countries. So the question I have is do you think do you see some leeway to adopt a risk-based approach when you assess the adequacy of countries, or should you be conducting this assessment for every single third country that you're transferring data to?
I think legally speaking, the answer is easy, I'm afraid. There's not much room in the recommendations and possibly not in the court judgment. So you'd have to look at what you mapped in step one. You'll have to tick it off. What I would try first is, and that may be easier, but not for all organizations, is to trim it down. Either trim down the transfer or the onus on whom you can put this. Maybe you can go to industry associations. Maybe you can tap sources that already did this. And this will go together with the risk-based approach, which we will go into also, I think. So the question is maybe not so much, can you take a risk and just jump certain countries and assessments, but maybe what can you do before that? Can you trim it down before so you don't have to do all of the assessments? If you have to choose, and you will have to choose, what Phil said earlier, and also Olivier, you'll have enough at your hands. You can't do it all, and simply not in a fast manner in a short period of time. So you will have to prioritize, and GDPR generally allows that, but it's a question of the greater risk-based approach. If I were in the company making the decisions, I would definitely try to prioritize and then see how much you can do at the beginning, and I would prioritize this by risk. But you would have to expect a regulator, if they look into this, that you'll have to do some explaining.
Yeah, and I think you mentioned that the legal answer is quite easy. That doesn't happen all the time. You're quite right that when you read the recommendations, it seems as if the EDPB is ruling out a risk-based approach. However, in the Standard Contractual Clauses, there is this phrasing that suggests that the likelihood of access by foreign government authorities is an element that may be taken into consideration. So it seems as if the Standard Contractual Clauses are offering a little bit more flexibility in terms of adopting a risk-based approach. Obviously, the Standard Contractual Clauses would be binding. The EDPB recommendations have a lot of authority value, but are not binding. Do you see a conflict there, and what would be your view on that?
Yeah, I think there is conflict there. It's not the first time between these institutions, the board and the commission. Maybe it has happened. We saw this in Safe Harbor and Privacy Shield to some extent. It's not new. it's not a real surprise. I think the answer is that you have first to look at what the risk-based approach can cover and what not. So my understanding would be that you can look at what you're doing, how you're designing the processing activity, and also what you're doing in terms of TOMs, technical and organizational measures, where there's an end and where you can't really dig deep is if you want to say, yeah, we know we're going to infringe people's rights, data subjects' rights and freedoms, and then take a risk, a business risk. That's a different thing to the GDPR risk-based approach. So you'll have to differentiate those two and then see how much you can dig down into each of them, because both, of course, from a business perspective are valid, even if only one of them is GDPR and the other is a commercial one.
Yeah, no, okay, yeah, that is a good point indeed. So you could obviously also take a different approach. I think we sort of concluded that it is very challenging for organizations to conduct these assessments, which, let's face it, in the end should be conducted not by the organizations but by the European Commission. The EDPB hasn't done these assessments and is not planning on doing those. So Olivier, knowing that in many situations the outcome of your adequacy assessment will be that no essentially equivalent level of protection is ensured, would it not be just an option to skip those assessments and to focus more on the supplementary measures?
Yes, I'm sure that many organizations are probably asking themselves that question at the moment. I mean, I think there is a risk in simply skipping the assessment of the laws in the third country. I think we have to be realistic. It's laid out in the EDPB's guidelines. It's required, so in theory, at least, we should be doing it. At the same time, I think that there are some third countries where there is no real surprise or doubt, if I may express myself that way, about whether the laws of that third country provide a sufficient level of protection or not. As it was already mentioned, following the invalidation of Safe Harbor and more recently Privacy Shield, we know that the laws of the United States do not meet the standards of GDPR and European law. Therefore, the question could be, is it even necessary or worthwhile, spending time and money making that assessment? I think, it's a difficult question, and I'm not sure there's a straightforward answer to that. I see where the challenge is going to lie is not so much on assessing the laws of countries like the United States. It's going to be assessing the laws of third countries that do not have adequate status, where the European Commission has not pronounced an adequacy decision, but nonetheless they do have data protection laws. And I'm thinking of countries like Australia, South Africa, or more recently Brazil, which is a good example of a country that has reinforced its data protection laws to be more aligned with the standards and the principles of the GDPR, but Brazil does not have, or not yet, an adequacy status. So there, I think, definitely there will be a benefit for companies to make that assessment, and it shouldn't be something that they would skip. That being said, I think the supplementary measures, as I'm sure we will come into more detail, will in any case, in 99% of the cases, they will be needed. So yeah.
Yeah. So well, not really a quick fix to this solution, unfortunately, from what I understand. I saw an interesting question coming in from one of the participants, and the question is as follows: in the future, will processors based in the EU or the EEA be obliged to provide controllers with their transfer impact assessments for sub-processors where the data will be transferred into third countries? So, what would anyone has want to comment on this question?
I can take that one if you like, Tim. I mean, generally speaking, whenever a controller is engaging a processor, there is an expectation in the GDPR that both parties to that relationship will cooperate in ensuring that there is, an appropriate level of due diligence that is conducted and the necessary contractual measures are put in place. I think that duty of cooperation is going to extend to a processor providing visibility of its sub-processors to the overarching controller, and the locations of those sub-processors in light of the Schrems II judgment, in order to ensure that that this kind of standard of essential equivalence can be met when data is shared with those sub-processors. I think that's the legal position. I think, aside from that, though, just commercially, I think there is going to be ever greater pressure now on vendors, on processors, when they are competing for a controller's business, to be able to show that they are being transparent about who their sub-vendors are and the locations of their processing. So whether you reach that answer by a legal route or whether you reach it by a commercial route, I think both roads end up at the same destination, which is going to be that, yes, processors will be expected to give that transparency and that degree of cooperation.
And if I may add to that, it might even be more onerous if you extend that and try to implement the full contractual chain alongside the processing chain. So if the controller wants full control, or at least more control than now, and try to push down, have the flow down effect, and maybe grant direct rights for the controller, which is not happening at the moment, and I don't think it's feasible. It's a bit like a discussion, the old discussion around audit rights. You don't want a million customers to drive by the data center and audit it.
Yeah, no, indeed. Indeed, that's absolutely true. And as I mentioned, at least on that point, the SEC finally recognized that reality. So we're making a little bit of progress. So I think, well, with regard to the adequacy assessment, by way of sort of interim conclusion, I think it's quite clear that this is a real challenge for data exporters, but I think also for data importers. They will not be able to ignore it, because as you mentioned, there will be a commercial motor behind it that will sort of oblige them probably to also engage with their data exporters. So before moving to the next topic, I would like to hear what the people in this call are planning. So we've come to our first poll. If all goes well, you should see a poll appear on your screen, and I would like to invite you all to vote, of course. So the question is the following. Is your organization planning to conduct adequacy assessments? Obviously, this is from the perspective of a data exporter, and we have 5 options for you. The answer could be yes, we will do that for all our transfers. The answer could also be yes, but only for some transfers in our country. So we'll adopt a bit of a risk-based approach. Option 3, we will do it, but only if we can share the costs with other organizations, perhaps sector federations. 4th option is blunt no, we don't have the resources to do this and we won't be doing it. And obviously a 5th answer could be, well, at this stage we don't know yet, which I could understand as an answer. So please cast your votes, and we'll be and I see currently a lot of people are still in the "we don't know yet" category. As I said, that is not surprising, and certainly not. Well, one should not be ashamed for that. Let's give it another few seconds to see if we have a few more votes coming in. Yes, so let's close the poll here, so the results are as follows. We have 45% of the participants who haven't made up their mind yet. Let's say closely followed by option 2. Yes, we will conduct those assessment, but only for some transfers and some countries. That option 2 got 31% of the votes. Interestingly, only 3% of the voters chose the option that they will only do it if they can share the costs with other organizations and or federations. That's an interesting one, because obviously a lot of those adequacy assessments will be done in parallel. So there's definitely room for optimization there. Anyone care to comment? Do you find this outcome surprising, or is it in line with what you were expecting?
For me, it is pretty much exactly what I would expect, to be honest with you. I think what you're seeing there is a general concern from organizations that they feel a need to comply with the law, which is why you are seeing, sort of what, 43%, sort of saying that they are going to do some level of transfer impact assessment. But I think it also reflects the reality that for many organizations, this is just an impossible ask to do the full sweep of all possible transfers all the way down the sub-processing chain. So I think you're seeing some degree of, common sense commercial risk prioritization, and of course a lot of organizations who are quite simply waiting to see what will happen, because I think, it's been part of the history of European Union data protection regulation that we make a lot of strict rules that we often don't enforce. Cookie consent has been a very good example of that. And so I think you'll see with a lot of organizations, they're waiting to see what the consequences are. And if we see that there are steep consequences to not doing these things, I expect more people will shift into the yes category. But at the moment, I suspect there are a lot waiting to see what will happen.
Yeah, well, you raise a very good point, Phil, on enforcement, and we'll come to that. We obviously have two colleagues from countries where we have some of the most active regulators, and it will be interesting to hear what they have to say about that. I have a second poll with regard to the adequacy assessment. If we could get that one on the screen, please. The question here is now, if you are a data exporter, what kind of input are you expecting to receive from your providers? Or if you are a non-EEA based provider, what kind of support would you plan to provide to EU-based customers? And here we have 4 options. The first option is, well, we expect our provider to make an off-the-shelf adequacy assessment available, and we will just take that and add it to our documents, our compliance documents. Option 2 is, well, we will do the assessment ourselves, but we will ask the provider for input. So we will ask him to feed in to our assessment. Option 3 is, we don't intend to involve our providers at all. We think we are able to do it, or we trust ourselves better to do it, perhaps. And here again, a last option, we don't know yet. Please cast your votes. Okay, so here, looking as the votes come in, I see that option 2 seems to be particularly popular. Almost half of the people that have voted indicate that they don't expect the off-the-shelf assessment, but they definitely will require some input from the providers. Let's give it a few more seconds. Yes. Okay, so 51% will request some input. 24%, that's 1/4 of the audience, is expecting to receive off-the-shelf assessments, or perhaps in that 24%, there may be providers who are planning to provide those off-the-shelf assessments as well. So we offered both ways. Again, what do you think? Is this also in line with what you were expecting to see, or do you think this is quite surprising?
Personally, I would have expected more to tick unsure, to be honest, and maybe in line with the other poll just before that one. Half or a little more than half wanting to do this with the help of the provider in the third country, I think looks okay to me, because it will still be a lot of work, but it's also in line with the idea from the judgment, Schrems II judgment, and the recommendations that you need to verify this on a case-by-case basis. That might be a bit of a European continental idea with the case-by-case approach, but it's in there, in the papers, in the judgment. So I have hopes, actually, that this would get many organizations a good way forward.
I think I'll just add to that, Tim, as well. What's interesting is that you can see that essentially 3/4 of the respondents are expecting their providers to give them some degree of input into their assessment, whether that's by means of an off-the-shelf response or by means of maybe something more nuanced, or maybe even that 50% is a combination of an off-the-shelf response with some follow-up questions. But either way, I think it clearly demonstrates there's a very strong onus on the providers to support the importers, the data processors, to support their customers in making these assessments.
Yeah, absolutely, Phil. Yes, well, thank you all for casting your votes. That was interesting. In the interest of time, I suggest that we now move forward to the next topic, which is an equally challenging one, the supplementary measures. So as I discussed, there's 3 types of supplementary measures. There's the technical ones, the contractual ones, and the organizational ones. But in reality, if you read the recommendations, it's clear that the real important ones are the technical measures. Phil, a question for you on encryption. If you read recommendations, it's quite clear that encryption and to some extent pseudonymization is the key measure, right, to legitimize your data transfers. But obviously, I mean, we need to be realistic. It cannot be used in every single scenario. There's plenty of situations where it is not possible, as the EDPB is expecting you to do, to keep the encryption key as a data exporter with you. So many situations, your provider, your service provider, will need to have access to clear data, whether it is because you are a multinational and you have intra-group transfers of HR data, might be remote IT maintenance that you've outsourced, or many SaaS solutions that really require the provider to access the data. What are the viable solutions to address these kind of situations? Because if you read the recommendations, then it is quite problematic in the EDPB's point of view.
Yeah, I mean, I'll be blunt and I'll say I think this is probably the most unrealistic part of the EDPB guidance, to be honest with you. And you know, what the EDPB is essentially saying is that if you were transferring data to a country with a known surveillance regime, where that data may be accessed in the clear, in other words, in unencrypted or unpseudonymized form, then then there is really no way of guaranteeing that data is safe, that it will be protected to an essentially equivalent standard. What I tend to think about when I think about that is email within organizations. If I email colleagues in the United States, those emails will contain my personal data or personal data about colleagues. Emails by their nature are sent in unencrypted format. So, I actually struggle to see a lawful way to send emails under the EDPB's guidance, which seems like a slightly ludicrous result. But to the point more generally for sort of cloud providers and the like, there are some services where data can be held in encrypted form the entire way throughout the provision of the service. A good example would be a cloud infrastructure provider where simply all they're doing is hosting the data. You can encrypt the data, you can put it on the cloud hosting provider, you can take it back again. Never needs to be decrypted by the provider. But for most software as a service based services, the data always has to be decrypted. That's just the nature of the service. You can encrypt the data in transit when it's being sent there. You can encrypt the data when it's being stored in a data storage location. But when the cloud provider is actually executing its software, its algorithms that have to read and do stuff with that data, the data has to be decrypted. And the effect of the EDP's guidance is basically to say that can't happen outside of Europe. The slightly worrying thing about that is that seems to point almost towards more of a data localization standard for Europe. And I don't think that's ever what the GDPR intended or what the EDPB really intends. But I think we need to be very careful about reading too much into the EDPB's guidance here.
Yeah, and I think you raised an excellent point there, Phil, about the location of the data, and it actually nicely brings me to my next question. which is more focusing on the contractual measures. We're seeing more and more. We have the reality, like you say, that a lot of the big cloud or SaaS providers are US-based companies, but most, if not all of them, nowadays have EU-based data centers. Do you think, Olivier, that agreeing contractually that your data as a data exporter will be hosted in the EU data centers of these typically US vendors, would that be a solution? And I'm particularly keen to hear what the CNIL's view is on this. I know that there have been some discussions around transfers of health data to the US, so I'd be keen to hear your thoughts on this.
Well, I cannot really speak on behalf of the CNIL, you know, so I would only be guessing there, but I can certainly share my view on that, and I think sort of in line with what Phil was saying, I think it's unrealistic to think that all data can be stored in the EU. I mean, I think there are many people in the EU who probably would like that to happen, would like all this data to be stored in Europe and sort of to build a bunker around, or a wall around, a virtual wall, should I say, around our data and protect it. You know, we can see that with some even sort of going beyond data protection, that there are proposals that, of the European Commission that are in preparation that clearly show that the European Commission is being more protective around information and data in general. But there is the reality, and the reality is that companies will continue to transfer data, will continue to rely on cloud service providers around the world. So I think, you know, it's what's going to be interesting is to see how the regulators are going to apply these rules, how they're going to interpret the rules, and how they're going to enforce them. And you know, we may be surprised to see that there may be some differences between the national DPAs. I mean, obviously the EDPB is the position of all of the 27 EU DPAs together and adopting together a common position. But at the same time, I think you know, we know that behind the scenes there are differences of opinion and different points of view between the regulators, and so I think it's impossible to draw too many broad conclusions, because every situation is going to be very different, and we will have to wait and see how the regulators in the different countries are going to enforce these measures against different companies. And hopefully with time we will then be able to extract you know, a more detailed understanding of how the regulators view these different rules.
Yeah, thank you, Olivier. Speaking of regulators, Thorsten, has any of the German regulators taken a view on whether data hosted on EU servers, but by affiliates of non-EEA providers, whether that is acceptable?
If you're talking about remote access and the likes, you know, if you're just hosting in Europe, but the access is made elsewhere, then it's not worth discussing the point. Remote access is transfer. If your business model hinges on this, you might want to try this argument, but this has been turf of pre-GDPR times under the law. I don't think it's worth discussing this. It'll be quickly regarded as, you know, as a ruse, I believe. And there's more, actually. So you have to be aware of certain regulatory guidance in Germany, and also some discussions and actually disputes between the individual federal states regulators, because we have so many of them. We don't only have one. For instance, the fine supervisory authority in Baden-Württemberg, they issued quite specific guidance actually on what you need to do in terms of supplementary measures, and you need to be aware of that. I'm not saying you need to heed that advice or recommendations, especially that we now have the board recommendations, but you need to be aware. And I mean, there's the pink elephant in the room. That's Microsoft's approach, just published recently. about their addendum. You need to be aware of that because not just in the Netherlands, also in Germany, there's been an ongoing discussion on this, and there's actually dispute, and in part it's being disputed publicly between different local supervisory authorities. In some way, it's interesting, almost entertaining to see the different views, also of case handlers, but in the end, this is a commercial disaster, I believe, because you don't really know what to do in one country alone, in Germany, and you should, that will be my advice, look to your local regulator if you're in scope of one of those in Germany, and then work from that, and also weigh it against other countries. If you do cross-border access, remote access, then I think you should actually leverage this, and if you want, push it to the board, because it has to be applied in a consistent manner across Europe.
Yeah, consistency is indeed a key point. So I sort of take away that even that approach is not offering is not a magic wand, unfortunately. Okay, well, I was going to say that's helpful, but not quite. Let's move to the organizational measures, which if you look at the hierarchy, even though the EDPB doesn't really mention it, they seem to be the lowest on the hierarchy. Phil, can you think of any organizational measures that an organization might take that would actually increase the level of protection? Because in the end, it's about whether or not governments, foreign governments, are able to access data, right? So what could you adopt as an organization to increase the level of protection on the organizational side?
I mean, this is certainly where I think there is more that companies can do and actually should do. So I think there are sort of two core organizational measures that can be taken. The first is obviously to adopt some kind of internal policy around how government requests for data will be handled. And I think in a nutshell, what we are looking for, or what EU customers will be looking for their non-EU importers to do, will be to commit that they won't voluntarily hand over their customers' data in response to a government request, that there should always be some process for trying to redirect the government agency to the underlying customer if they want the data. And if that's not possible for any reason, then for the receiving organization to commit that it won't voluntarily hand over data, it will only hand over data if it is under some kind of legal compulsion to do so. And appreciate that can then create some kind of conflicts between sort of non-EU and EU law, where you may have a compelling non-EU requirement to disclose data that maybe conflicts with the GDPR. But I think that has to be a better position than just voluntarily handing out data over without any kind of compulsion. So I think having a process where you won't voluntarily hand over data is one thing. Committing also not to engage in any kind of massive or indiscriminate transfers, which are really the types of transfers that the EU is worried about, I think is also very important. That can also go into policies, it can go into contracts. And then finally, you are seeing, I think, greater emphasis on transparency measures as well. So increasingly, you are seeing organizations now that will publish details of the number of requests that they get for data and how many of those they comply with and how many of those they push back on. You have to be a little bit careful with those because sometimes there can be restrictions under local law about what you can and can't say. But obviously, if you are able to publish reports that indicate that you could receive a very low level of requests and perhaps that you respond to an even lower number of the requests that you receive, then that has to go a long way, I think, towards reassuring customers and perhaps quelling some of the concerns about government access to data.
Okay, yeah, that is indeed a good point, Phil, and perhaps indeed something that organizations could focus on more in the future, in the near future. I'm conscious of time, so I think we'll need to move to the topic on the practical questions, and obviously one of the main practical questions that we have now is what is the timing, well, relates to the timing to take action. I mean, following the judgment, the Schrems judgment this summer, it was already clear that supplementary measures had to be taken. We know, and I think, Phil, you mentioned that typically in with the EU rules, companies take a wait and see position. So a lot of organizations haven't implemented supplementary measures. And now we have these draft standard contractual clauses. So what would be your recommendation, Thorsten, when it comes to implementing those supplementary measures? Should you act now, or can you take the risk, let's say, to wait for the new standard contractual clauses to be implemented and then cover everything in one go?
Yeah. Again, I'd like to differentiate between sort of the legal view, which might be easy, again, one of the rare occasions, and a risk-based approach, if we can take it, which I will try to make a case for. So on the legal side, if you haven't done anything, you're already late. You need to do something. And we're talking about supplementary measures here, but before that, at least in Germany, the regulators have been clear and vocal. You need to have done something by now, today. If you haven't done the first 2 or 3 steps, you're out. No discussion, possibly, depending on your very specific local regulator. And you need to document what you're doing, why you're doing it. Even if you're taking a risk-based approach, you have to have something in the drawer. And when it comes to the next step, the supplementary measures themselves, I would try to argue for the risk-based approach because you have to prioritize. You can't do everything at once. It might not get you all the way, but I would at least try to get into the discussion and to avert the fine or the formal measure in terms of interdiction, all of which can happen. Absolutely. They're on the table, these measures, all of them and more. Than the ones I've mentioned, but I would try again to limit, if you can, the transfer and use, if technological measures are available, use them, although I'd be cautious of implementing new ones. Again, I think, as Phil mentioned earlier, we'll see commercial push to vendors that controllers, data exporters will ask them to have something at the ready, which they can use to at least use a risk-based approach on the technology side. But also being conscious of the time, I'll hand back to you, Tim, to perhaps give some closing remarks to the colleagues.
Thank you. Yeah, well, I was just going to add, but I guess it's linked to what you were saying. The same question when it comes to timing. Obviously, we have the same dilemma with Brexit, right? The end of the transition period is approaching. So if no adequacy decision is adopted by end December, then as of the 1st of January, the UK will be a third country. Should organizations repaper now and implement model clauses, the current version, obviously, or do you think that they could take the risk to wait until the new SECs are adopted, which hopefully will happen early 2021?
Well, yeah, the million-dollar Brexit question. As the resident Brit on the phone, I suppose I ought to take that one. Obviously, when we talk about Brexit, we've got to think about 2 scenarios. We have to think about data transfers outside of the UK to the rest of the world, and we have to think about data transfers from Europe into the UK. The short answer for data transfers from the UK outside of the UK is that if they're going to the EU, it's absolutely fine, not a problem. If you were transferring to other countries, then essentially the same rules apply for transfers from the EU. So you have to have some contractual clauses unless it's to an adequate country. The good news for us is that the sort of European standard contractual clauses are essentially being imported into UK law. So if you rely on standard contractual clauses for your exports from the UK now, you will continue to be able to do so after the 1st of January next year. For transfers into the UK, it's a little bit more tricky because, as you said, Tim, it depends on whether or not we get adequacy. I think all of us had hoped that we would know by now whether or not the UK was going to get adequacy. Obviously, we don't. I suspect it's going to be a very political process, and even though it's not technically tied to whether or not we get a trade deal, I think politically it probably will be tied to whether or not we get a trade deal. In terms of whether you repaper now and sort of prepare for the possibility that we might not get adequacy, to be honest with you, we haven't seen many clients do that yet. I think many are still working on the assumption that the UK will get adequacy, but we are starting to see the first signs of anxiety where maybe some clients are starting to put standard contractual clauses in place, but maybe with something like a condition precedent in the document that says these SECs will apply only if the UK doesn't get adequacy. So in other words, if we do get adequacy, they never take effect. If we don't, then the SECs bite. But I think at the moment, I'm as eager to know the answer to the adequacy question as everybody else.
Yeah, well, I think that makes two of us, and probably even much more. I'm looking at the clock, and although I have the feeling that we could continue discussing for a few more hours, I'm afraid we have run out of time. We will, at Phil Fisher, obviously continue to closely follow up on this topic. So I would say keep an eye open for subsequent webinars when the final versions of these documents are adopted, hopefully in a very near future. I would also suggest, if you want to read more, view more, make sure that you see the updates on our privacy blog and also our privacy channel on YouTube. And with that, I would obviously then like to thank you all for attending and asking your questions. I know we haven't been able to reply to all the questions, and I'm truly sorry for that. If you have questions, feel free to reach out to one of us. We'll be happy to answer additional questions, and obviously we hope that you found the webinar useful. Thank you all for attending, and hopefully we will be in touch soon. Bye.
Thank you all.